Welcome and thank you for joining Seyfarth's webinar, Negotiate Like a Pro, Expert Advice for Getting What You Want. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right-hand side of your WebEx window. We will do our best to get to everyone's questions at the end of the program. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down as it will not be repeated and is required for CLE credit. Copies of the webinar recording and materials as well as a CLE verification form will be distributed to attendees following this presentation. At this time, I'd like to turn the program over to our moderator, Eric Barton. Eric?
Thank you, Kristen, and thank you to everyone who's joined us today. My name is Eric Barton. I'm a litigation partner here at Seyfarth. And probably like most of you, there isn't a day that goes by that I don't find myself negotiating. I might be negotiating the terms of a settlement with opposing counsel. I might be advising a client on their negotiations of a business deal, or I might be negotiating with my two daughters why they can't have a cookie before they go to bed. And as you can probably imagine, I am more successful in some of those negotiations than others. And why is that? Well, we've all heard the saying that negotiation is an art. And while there is certainly some truth to that, in my experience, there's actually a lot more science behind negotiation and what makes a negotiation likely to succeed. And that's really the central idea of what gave rise to this webinar today. I wanted to sort of take a step back, if you will, from the trenches of negotiation and really examine clinically what someone needs to do to increase their chances of reaching a successful deal. And to accomplish that task, I reached out to two true experts in this field, Professor Michael Sachs and Hunter Hughes. Professor Sachs will begin today with a discussion of competitive versus collaborative negotiations and why it's so critical that we understand what type of negotiation we find ourselves in. Hunter will then piggyback off that and present on the importance of preparing for a negotiation and the things we need to do to prepare to succeed. And despite the Boy Scouts trying to always teach us to be prepared, the reality is that many of us simply just do not prepare adequately for a mediation or a negotiation. So as Kristen indicated, at the end of the two presentations, we've made sure we've got enough time that everyone can ask questions. And if you would just type them into the box, I'll be keeping track of those, and I'll do my best to present those to the speakers, and we can respond to as many of them as we can. And again, for the lawyers in attendance, I'll be reading a CLE code at the end of the webinar. And so with that said, before I turn it over, allow me to just briefly provide an overview of our two speakers, and then I'll hand it over to Professor Sachs. After earning his PhD in organization, behavior, and sociology at the Kellogg School of Management at Northwestern, Professor Sachs has been a faculty member at the Consueta Business School at Emory University for the past 20 plus years. He also serves as a professor of sociology at Emory College, faculty director at the Woodruff Leadership Academy, and a faculty director at the Emory Executive Education. Professor Sachs' teaching is centered around the area of strategic alignment, and among other topics, Professor Sachs has extensive research and teaching experience in educating professionals, attorneys, executives on negotiations, ethical decision-making, strategic thinking, and conflict management. Hunter Hughes is a Chambers-rated mediator and arbitrator based in Atlanta with his firm Hunter ADR. He truly has a nationwide practice that focuses on class, collective, and complex cases, primarily involving employment, securities, ERISA, and other business disputes. He has successfully served as the mediator in many large matters, including the Publix, Home Depot, Coca-Cola class actions. And since 2000, Hunter, it's my understanding, has either mediated or arbitrated over 1,000 cases. So it's not his first rodeo. So with all that said, I'm going to turn it over first to Professor Sachs, and the floor is yours, sir.
Thank you for the kind introduction, Eric, and good afternoon, excuse me, everyone who is joining us. So as Eric said, my name is Michael. I'm a professor in the Guzweta Business School at Emory. And I'm going to give you just a brief personal introduction, the main point of which is how I came into this field. Some people know from years what they want to do, but for many of us, it's a circuitous path. I say that because one of the things I want to dispel is the notion that negotiations is all about things like buying a car, buying a house. Of course, that's negotiations, but there's so much more to it. And so I want to tell a little bit about how I came into it, and it might resonate with you. Then we're going to dive into some business topics about how this actually works. So very briefly, I was born and raised in Philly, wanted to go somewhere totally different for school. And I was kind of raised middle class. And so I moved to California with some relatives, got California residency, went to UC Santa Barbara as an undergrad. I was on financial aid, so I was on work study, and I worked my way through school. By age 21, 22, I had already had about a dozen different jobs. And one of the things that intrigued me was some of them were pretty good workplaces to work, and some were, you've got to be kidding me, bad. Nothing's perfect, but some, people generally got along, and the department generally did well, and some it couldn't have been designed worse. So at an early age, I had this curiosity: why are some workplaces great places to work and others total nightmares? And I don't know about you, but I've experienced both. It's tough. You get up in the morning, you do whatever it is that people do to hair. It's at a loss for me, but you have your coffee, you eat breakfast, you're driving in, and you're already dreading being there. That's a sign that our culture is holding us back. Conversely, if you're genuinely and generally excited to go in, that's where our culture is helpful. One of the things that makes culture either a great place to work or not is how we all work with each other. And so again, negotiations isn't just the financial part, it's also how do we navigate the intricacies of working with other really talented, smart people. And as Eric mentioned, it's also at home, negotiating dynamics at home with family and friends. It's a life skill that when you get really good at it, it benefits you and everyone around you. So I wanted to go to grad school to study something about like conflict in organizations. Applied all over. I got lucky. I got into my top choice. I moved to Chicago for 6 years. I was at Northwestern studying conflict and negotiations in business. Came to Emory on a 1-year contract. I'd never been to Atlanta before. I'd heard great things about Emory in Atlanta. And my goal was to pay off some student loans, to buy a new car because my car was literally falling apart, and to figure out what to do with my life. And that got extended to a 2-year contract, to a 3-year contract. And now this is year 21 at Emory. It's the longest I've ever lived anywhere. I've been very privileged to serve in a number of different roles at Emory, each of which is different. Each of which, again, involves a negotiation for what's the best way to structure this role in a way that I can succeed and that Emory can succeed as well. So let's move forward. I'm ready for the next slide, and we'll start digging into how negotiations work for law firms. So what's really ironic is the first class I ever taught was a joint negotiations class between business students and law students at Northwestern, at the Kellogg School and the Northwestern School of Law. So early on, I kind of fell into this. And since moving to Atlanta, I would say the #1 industry I've been involved with is the legal industry. #2 is probably healthcare. One of the things both of these industries have in common is they're both very successful, highly trained, really smart people working really important stuff. They happen not to be trained in what I am. And no disrespect, quite the opposite. What I find is when I'm involved in teaching and training for law firms, people pick it up quite quickly because they're really smart. They get it. They just weren't exposed to it in law school. I often say, how many classes did you have in law school about how to manage people? The answer is usually 1 or 0. How many classes did you have in law school about anything that's business related? And the answer is, usually maybe 1 or 2 or sometimes 0. So this is just some examples of some firms that I've worked with. Doing a number of different things. One of them is the topic we're talking about today. Is negotiations is a learned skill, not a born skill. And really smart people who are experienced with this can pick it up quickly. Sometimes they just need some structure and some ways of thinking about it to improve their skills. So what we're going to do today is we're going to give an overview of some of these skills, and hopefully we'll have plenty of time to talk about it. Ready for next slide? So typically, when I do some training, I will throw this word up, and I'll say, what are the first thoughts that come to your mind? The answers I often get are yuck and run away, or for lawyers, what I often get is this is what we deal with every day. And I once asked, I'm close friends with our general counsel at Emory, great guy. And I said, what percentage of the cases that come to the Office of General Counsel are legal? So keep in mind, these are all lawyers at Emory. He said about 10%. So what are all the other 90%? He said, they're about conflict that are non-legal, but people think that they should be coming to our office. So I imagine as lawyers, I know you're not all lawyers, but for those who are, you might deal with a combination of absolutely some legal things, but also some interests that are non-legal. And how do we figure both of those out? So there are some myths about conflict that are true, but only partially true, and negotiations is the means to resolve them. I want to very briefly talk about 4 of the most common myths about conflict. Then we'll talk about how negotiations is the means to resolve them. Next slide, please. So the first one is that conflict can be avoided. So one of the things that I recommend, and I'm always happy if you have any questions, feel free to email me. I can send you readings. I can send you websites and links. One of the things I recommend is something called the Thomas Kilmann Assessment, or TKI. It's the most used self-assessment for conflict skill around the world. So highly recommend it. You can find it online. And it breaks things down into 5 conflict styles. One of them is avoidance. I'm in the 97th percentile, for conflict avoidance. So trust me, if there is a way to avoid it, I would have found it by now. The fact is there's no way to avoid it. In fact, the business definition of conflict is simply disagreement about how to get our jobs done. So it's not necessarily people yelling and screaming, it's just disagreement. If you accept that definition, we engage in conflict every day. Some of us, in my case, multiple times a day. So we cannot avoid it. We may as well learn the skills to deal with it. And in fact, if we are proactive about dealing with it, conflict can be a positive thing, which we'll talk more about in a bit. The second myth is that conflict is always unpleasant, like 2 people yelling and fighting. And sometimes it is, and I imagine many of you in this meeting have had those experiences. But I hope you've also had the experience to talk to a friend or a colleague whom you like and trust, and you just disagree. The person I consider my best friend at Emory, we are like yin and yang. We are, all of the personality assessments say we're opposites, we have opposite backgrounds, but we trust each other completely. We disagree more often than we agree. And I value him so much because when he explains his perspective, sometimes I haven't even thought about it. And sometimes I might even change my mind, sometimes I don't. But actually, conflict can be one of the most pleasant learning enhancing experiences you can possibly have if you can form a foundation of trust. We'll go to the next slide for the next 2 myths of conflict. The third is that conflict is a waste of time, like 2 people pushing against a wall. Sometimes it is, but sometimes conflict is the most productive thing you could possibly do. I'm working with a firm in Alabama, and the short version of the story is there's about 20 partners. 10 of them want to change the strategy for how their firm works. 10 do not. They are literally deadlocked. And so, as you can see, this is incredibly important. And I'm working with them to kind of resolve this tie and figure out what will their strategy be moving forward. So it is the most productive thing we can do to engage in conflict sometimes and to figure out what do we need to do to move forward. In fact, if we don't engage in conflict, we are wasting time sometimes. And the last one is that conflict is a fight. And as you'll see, if we broaden the definition of our topic for today, sometimes negotiations is a fight, but sometimes it's just managing people in your life. And the last thing that you want to do is fight, much better to collaborate. So negotiations is a broader set of skills to manage the people around you, not just to fight over money, though that is certainly the case at times. All right, next slide, please. So very, very briefly, I sometimes talk in more depth about the costs of not engaging in conflict. So I'll just give you the overview. Many of us fear, oh, I don't want to talk to him. I don't want to talk to her. I don't want to engage in this conversation with this employee, with this other business. It's understandable. What if the conversation goes badly? What if we end up in litigation? These are all understandable. But what I want you to think about the costs of not engaging in conflict. I won't go over all of them today for the sake of time, but you can see some pretty important consequences when we don't engage in conflict. In fact, I know some firms and some organizations in general that are nice places to work. People get along, but they actually get stuck because they don't talk about the most important things that are holding them back. And so with more time, we can talk about productive versus unproductive conflict. Productive conflict is how do we negotiate with each other to resolve things to make our lives easier moving forward. Unproductive conflict is the nastiness and the bitterness that holds us back. All right, next slide, please. So one of the things that I want to, that I hope that you really think about moving forward is if you can improve your skills on this topic. And it's a learned skill, not a born skill. I didn't know anything about this when I got trained in it. And so with time, we can all get a lot better at this. For the firms and companies you work with, better business deals, higher profit, enhanced long-term relationships. Who doesn't want that? And as I mentioned, Hunter may get into with the topic of mediation. It can save money, time, resources, make everyone's life easier when you are skilled at this. It's also good for you individually. Most people are not good at this. And so if you can successfully negotiate deals for your firm, for your companies, for yourself, there's a lot of respect from your coworkers. It's value you add to your employer, It's usually interesting and challenging work. It's never the same thing twice. So it always keeps you on your toes. And there's tons of opportunities for personal and professional development. I have found it's a very humbling experience to go through. Not all of them go perfectly. And when I make mistakes, I try to be resilient, fix them quickly. And I find it's a great opportunity to advance my own skills in the process. All right, next slide, please. So now what I want to briefly do is introduce you to two types of scenarios. They're very different. The skills you need are very different. One is competitive negotiations. I found this picture years ago, and I've used it ever since. We have two people shaking hands, dressed formally with friendly body language with baseball bats behind them. Never mistake the tone of a negotiation for its structure. So you might be the nicest guy or woman in the world, but if it's a competitive negotiation, the goal is to win that one. So I thought, what's the best example I could succinctly offer for this? And on the next slide, which I'm ready for, you'll see it's a picture of our slimy car salesman. So he might be the nicest guy in the world. He truly could, but he doesn't care about your interests. I've seen them. I've seen car dealers train in negotiations, and they have two main interests. So one is to sell as many cars as possible. The second is at the highest margin as possible. And that's it. All the questions they ask you are to try to achieve those two goals. And so again, it's not a personal comment. Might be a nice guy, but he's not trying to help you. He's trying to achieve those two goals. And so if you are going to go car shopping sometime soon, you can read more about this. But what you want to do is, of course, do your research ahead of time, because they're going to ask you two questions. One is, tell me about how much money you're looking to spend today. And because I want to guide you to the best car that I can get for you. What he's really asking about is your reservation price, which is, what is the maximum amount of money you're planning to spend today, so I can suck as much out of your wallet, pocket, purse as possible. And if you answer that question, about $30,000, you should be prepared to spend that or even more, because he'll try to upsell you. Another question that they'll ask is, tell me, what do I have to do to get you to drive out of here in one of our cars today? If that sounds familiar, again, they're all trained in this, and there's phrases they're trained in. What they're trying to do is say, what can I do to prevent you from having a batna? A batna is your best alternative to a negotiated offer, which is really, really important. So your BATNA is your backup plan. What will you do if the current negotiation fails? The stronger your backup plan, the more leverage you have. The weaker your backup plan, the more desperate you might be and or seem. Some of my MBA students now have 4 job offers. So their BATNA is take one of the other offers. It puts them in the driver's seat. They're calmer, they're more relaxed. If one offer doesn't work out, no problem, I'll take one of the other ones. And it gives them more leverage to politely push a little more. Conversely, some of my other students have only one offer. Their BATNA is move back in with mom or dad, or move in with the boyfriend or girlfriend, or keep looking for another job. Those are weak BATNAs, therefore it weakens their ability to negotiate. So the stronger the BATNA, the more power you have in the current negotiation. So with a car dealer, that's easy. You just go to multiple car dealers and you get a much better sense of the deals that you get, and you can leverage one off the other. Scary statistic though, 40% of Americans buy their cars from the first lot they go to, 10% pay sticker price, like they're buying a can of beans from the supermarket, because Americans hate negotiating. That's why people like me have jobs, and entire industries have evolved because people don't like to negotiate. So that's why it's so important. If you're comfortable with it, you're actually in the driver's seat, literally and figuratively in this case, but a lot of us don't feel that way. Next slide, please. So a bargaining zone is a zone of possible agreement, and you won't necessarily know until afterwards, but there are ways that you can sense it. So remember, the reservation price is the highest or lowest I'm willing to spend. The bargaining zone is positive if it's possible for a deal. So I've done M&A negotiations, for example, which can be really complicated, multi-million dollars. And sometimes it's obvious there's no deal possible because it's a negative bargaining zone, or simply the parties could never agree. Other times a deal is going to be easy. It just depends how good the deal will be because there's plenty of room to negotiate. So one of the things you can try to figure out ahead of time, is this going to be an easy deal, or is it going to be a tough one, or is it we shouldn't even waste our time at all? There's no way these parties could ever come to a deal. That's why preparing ahead of time helps you understand what you're walking into. Next slide, please. So to wrap up competitive negotiations, these are typically short term. The obvious examples: buying a car, buying a house, flea market, scalping tickets. When we were traveling internationally, buying souvenirs, things like this. There's more of them than you might think of, but they're competitive because we don't particularly care about the other person. Hopefully we're being respectful and kind, but it's a short term, typically about money, directly conflicting interests. And there's a lot of psychological tricks that we can talk about that will help you in a competitive negotiation. But as I mentioned, it's not the only style. Most people, when they think negotiations, they think competitive. For many of us, collaborative is more common. And so we'll turn to that second style very briefly, and then I'll wrap up and turn it over to Hunter. Ready for the next slide? Oh, I forgot. So obviously we don't have time now, but something to think about is, what competitive negotiations are you involved in? And how can some of what I just introduced you help you do them better? Okay, now we're ready for collaborative negotiation. So the very brief version, ready for next slide already. Collaborative are long-term relationships about interests. So I'm not a lawyer. I can't handle the legal aspects. Anytime anything legal comes up, I of course immediately say, I know some people that can help you. What I handle are interest-based negotiations. Very briefly, there's something called the iceberg model for this. I didn't come up with it. What you see are people's positions. It's a statement of what they want. I want a car, I want a house, I want something else. Interests are the hidden things that we can't always see. And so what someone says they want isn't always exactly what they actually want. So a great example is sometimes it's about money. People will come in asking about money. And sometimes it is about money, but sometimes it's about respect. Sometimes all people want is an apology, or sometimes people want to repair a relationship, and money becomes a proxy for these things. So of course, absolutely, sometimes money is the case, but sometimes it's about repairing a relationship. So what someone says they want may or may not be what they actually want, and that's where collaborative negotiations comes in. How do we figure out what people's interests are in order to get there? Next slide, please. 30-second example. At Emory, we were trying to recruit a chaired professor, which is the highest ranked person you can get. Long story short, he had asked for a corner office, and I wasn't in charge of putting together his package, but I said, hey, can I talk to him about that? Long story short, he was a great guy, very transparent. I said, I see that you've asked for a corner office. You know, can I ask why? He said, yes, this will be my third university. And my previous university, my office faced a brick wall, and I hated it. I'm an outdoors guy. I realized that I was less productive. And so I wanted a view of something because I'm more productive that way. I said, okay, I totally get that. I'm an outdoors guy too. You know, the office, the building you'll work in, there's a beautiful view of the city from the top floor. How about I walk over there and I'll call you back and I'll show you. Went into one of the offices. He said, oh my gosh, that's a beautiful view. That would be great. Say, it's not a corner office, but I can get you a nice view. He said, no, that's great. The only reason I asked for a corner office is they tend to have more windows, thus a better view. So he asked for a corner office because it was his position. His interest was, I want a nice view. Moral of this short version of the story, there's only 6 corner offices in this building and they were already occupied. There were 10 empty offices on the top floor of the building with really nice views. So sometimes what people say isn't exactly what they want, and it's easier to meet their interest than their position. Next slide, please. So to wrap this up, collaborative negotiations are kind of like a jigsaw puzzle. It's a problem. It takes a lot of creativity. There could be dozens, there could be hundreds of ways to resolve it. So we're trying to figure out, how does each party's interest work, and then what's the possible mutual gain they can both have. If you can build a relationship of trust, it's just figuring out what's the combination of items that we can all put together to maximize benefit for everyone. Next slide, please. So same question. Think about what we just talked about. How might it benefit you and the people in your life, applying those principles for collaborative negotiations? So to wrap up, there are very different types of negotiations. Claiming or competitive negotiations are the ones that are more money-based, they're more short-term, they're typically about individual gain and there's not a future relationship. Creating value or collaborative negotiations are partnerships. They're long-term relationships, B2B deals where there is an ongoing relationship, and the skills and the approach are very different. Some of you might be great at the first, not so good at the second, or vice versa. I was born not good at either one of these. I had to learn, but again, it's a learned skill, not a born skill. And I'm a lot better than I used to be through practicing and through learning. All right, next slide, please. So wrapping this up, what you want to do is decide ahead of time what you want, define your BATNA, reservation price, figure out what situation you're in, employ the appropriate strategy, and ask really good, thoughtful questions to deeply understand the interests of the other side. Slide. So other issues, I realize this was very brief. There are other issues that you might be interested in. I know Hunter is definitely going to talk about the rise of third-party negotiations. There's also things like culture, international ethics. If you have any interest for more information on any of these, just feel free to send me a note. I'm happy to send them. I don't want to take more of your time. I think I have one more slide, then I'll turn it over to Hunter, of course. And that was it. So thank you very much. I'll now turn, I guess, back over to either directly to Hunter and we can go from there.
All you, Hunter.
All right. Thank you, Professor. So those are some very thoughtful and good concepts that can apply to virtually all types of conflicts and negotiations. What I'm going to do is narrow this down and focus really on litigation settlement. So that's what I do. I spend an extraordinary amount of time dealing with settlements, and somehow I've struggled through it enough to pick up a few hints. And I just want to share with you a couple of those, but I want to get focused in particular on just what we do in mediation, and which is obviously nothing more than negotiation between two litigants. And we don't really have one of these creating some special relationships very often. More often than not, this is just a pure distributive type of process. We've got a pie and we're going to see how it gets distributed. It's going to be cut up, and of course, each set of lawyers is trying to cut more of the pie in their direction. There is a BATNA, just like the professor was saying, in connection with these types of negotiations. The BATNA here is either you're going to settle it or you're going to litigate it. That's your BATNA. We don't have an additional house. We don't have an additional car. You got two choices here. We're going to settle this or you're going to litigate it. And what we're really trying to find out is what is your BATNA relative to a settlement process. And that's what I call litigation risk analysis. For me, the most important part of a mediation happens before you get there. It's the preparation. I suspect y'all have heard that before, but if you haven't, I'm going to say it to you as clearly as I know how. You got to be better prepared than the other side. Yeah, it's interesting to talk about what kind of opening offer you might have, whether or not you can get some anchoring processes in place, or whether you're going to do good guy, bad guy. All of that's interesting and may be helpful. But the real issue is which party is prepared the best. And from my perspective, the issue that we really want to talk about is who has prepared best in valuing the case. Litigation risk is simply nothing more than saying, what's the value of this case, and set a number. And that's what we're going to be talking about, setting a number as to the valuation of a case. When I ask a lawyer in a mediation, tell me about your case. Are you likely to win? Why is it a good case or a bad case? They'll give me an intuitive response. I'm literally 90% of the time, and they'll say to me something along the lines of, boy, we've got a really good chance of winning this. I'm not sure whether good chance is 51% or 91%, but I'll accept your word for it that it's a good chance. But what I'm really looking for is give me some specific probability. They'll then turn around and say, well, I've got a good jury pool. And I'm telling you, that's really a waste of my time and your time. Might be true, might not be true, but it's not something that's really telling me what the risk analysis is. What we want to do is take this intuitive valuation of it's a good chance of winning and turn it into something that's more probabilistic. If I could say the word, that would be helpful. But let me talk about intuitive decision-making, because that's what folks do on a day-to-day basis. There's a book called Thinking Fast and Slow by Daniel Kahneman. It is a first-class book. It runs about, 400 pages, but it talks about thinking fast and slow, not surprisingly, since that's the topic. What are they talking about there? As human beings, we, in the most simplistic way, we think in two different ways. One is on a fast basis, or it's automatic thinking. The second one is on a slow basis, which is some logical thinking or some sort of systemic type thinking. So let me give you two quick examples. Let's just say that you're sitting in a room and in walks, somebody, let's make it up, a movie star of some type. And then they turn around, they're there for 10 seconds, they turn around and walk out. And I turn and ask you, well, what did you think about that? And automatically you will say something, I don't know what, I thought the person looked cool, I thought the person looked good, I thought they were too short, gee, I thought he was too long, I really thought that this person would be X, Y, and Z, and turns out they are not. That's automatic thinking, and generally we use some sort of heuristics in doing that. That's thinking rules of thumb, but it happens automatically. It happens quickly, and by the way, it doesn't hurt your head. It is just simply what happens automatically. But what about slow thinking? That's some type of systematic thinking or logic-based thinking. So let's assume I ask you the simple question of multiply for me, if you would, 17 times 24. Now, I can do it, so I suspect all the rest of you can do it, but you might do it in a different way. For me, I think what I would do is I'd take 17 times 20, which is 340, and then I'd go 4 times 17, and I go, well, that's 68, and then I can add those two together, and I get 408. You might do it a different way, but you'll do it in some sort of systematic way, and you'll do it through steps, almost assuredly. And that's typically slower thinking. And for me, if I do sit in a room and I'm working hard on something and I'm concentrating on it and I'm trying to be logical about it, after a while, I get a headache. I don't know about you, but I get a headache from that process. And so I, like most everybody, not most, everybody else, you prefer fast thinking over slow thinking, the intuitive thinking over the non-intuitive thinking. And when you make decisions using intuitive thinking, you make errors at a very high rate. And for purposes of negotiation or settlement negotiations, you make what's called decisional errors. That's not rocket science either. Assumes you're negotiating with somebody and your final offer from the defendant to you and your plaintiff is $5,000, and you turn it down and you go to trial. And guess what? You get $5,000 or less. That would be a decisional error. You made a mistake. That's an error. You should have taken the offer. And let's do the flip side of it here. Very simple again. The plaintiff says, I'll take 5,000. The defendant says, no thanks, you go to trial. And the result is 5,000 or more, 6,000, 10,000, whatever it is. Defendant made a decisional error. And those decisional errors, as I say, are driven in significant measure by instinctive thinking, automatic thinking. For what it's worth, and there are studies going back into the 60s and all the way through into the last decade and into this decade, about 60% of the time plaintiffs make decisional errors. In other words, they get an offer and they turn it down and they get less at trial. Interestingly, though, in these studies, they've been coming up recently at a loss of somewhere around $70,000, give or take 70, $75,000 is what it costs them. That's the economic cost of that error. Well, defendants, they think they're a lot smarter. Of course they do. And they make lesser errors. Actually, they come in around 20% of the time they make an error. But the problem is that when they make an error, it costs them roughly 15 to 20 times more. The average number is well over $1 million when the defendant makes the error. These differences between 60x% and 20x% are, again, they are driven by various biases and intuitive conduct that give rise to these kinds of errors. Clients also, not surprisingly nowadays, are entitled to some sort of sound economic analysis, sound analytical analysis, something better than, I think we got a good chance. Trial lawyers, in particular, need to be able to give each part along the way, whether it's the beginning of the process, middle, or right before you go to trial, they ought to be able to give a specific projection on a specific number of what the trial outcome is going to be, an evaluation assessment. And to do that, the way you do that is fairly straightforward, although it's not often is not simple, but it's fairly straightforward. What you really do is take each of the uncertainties associated with the process and you disaggregate it. And I'll give you an example here in a couple of minutes. What you also need to do, and this is much harder in my experience, is you need to assign a financial value to the client's quantitative and qualitative interests. In other words, when you have a litigation and you're talking about settlement, it's not always that the dollar value of the settlement, if you do an analysis of it, it's controlling. I mediated a case within the last year or so where when you did a reasonable analysis of it using some relatively thoughtful basis, the numbers came out in the low 6 figures. We settled that case for 8 figures. Well, there must have been something that's really important to the client. And needless to say, I obviously know what happened there, but they had these qualitative interests that were absolutely driving the entire process. How you value it, it's very tough. I don't have any magic as to that other than talking at length with your client. But again, you need to assign financial value, both as to the probability of success in the litigation, as well as the financial value to the client. So let me talk about a risk analysis model. And there are 2 or 3 or 4. If you go online, a couple that I think are relatively good. One of them's called Palmer's Case Value Analyzer. Okay, if you go online and look at it, they'll give you a little sample and you can see how it works. It's basically nothing more than a decision tree without actually showing you the tree. There's another one called Tree Age Pro, and it uses some of the decision tree analyses that I'm going to talk about. There's a fellow named Mark Victor, who's a lawyer who's maybe 25, 30 years ago started doing decision tree analyses, and he's written a bunch of articles on it. If you just look up his name, Mark Victor, and decision trees, you can read as many articles as you want on it, because they've probably written 10 on it, and they're worth reading. Regardless of how you do your analysis, they're worth reading. But the simple process is this, of what a decision tree is and the way that Mark Victor does it. You take the underlying uncertainties or factors in a particular case that are material. What are the material factors that impact liability? And separately, you look at the material factors that impact the damages. And then what's an uncertainty for a trial? Well, I'm going to use probably one of the most simple examples would be summary judgment. If you've ever done an employment case, which I suspect many of you have, almost always the defendant is filing for summary judgment. And that would be one of the uncertainties. Another simple uncertainty would be, obviously, if you aren't successful at summary judgment, then you've got trial. You've got a trial verdict, and the third one would perhaps be appeal. In some of the more complex cases, you would break it down even further, and you could break it down a lot further than what I'm going to describe, but I'll give you one quick example. You would look at, on a decision tree, a motion to dismiss. You'd also look, I do almost exclusively class actions, so it's a critical part of that process. Not surprisingly, is certification. Is the judge going to certify the case? That is obviously a critical uncertainty. In a variety of different kinds of cases, such as a malpractice case, a Dalbert decision of whether you're going to get your expert in there. There's going to be evidentiary rulings. For example, a court could say, no, you're not going to be able to put in lost profits. Well, that's going to have a dramatic impact on what you think your damages are, and so on. So you can have lots of uncertainties. I'll use two simple ones, though: summary judgment and then a trial verdict. What you do is then, once you are looking at those, and I'm going to identify those two, summary judgment and trial verdict, what you would do is you'd list the pros and cons. The pros over here, you would say, all right, here are all the reasons why I think I'm going to get summary judgment. It might be that because something to do with the judge. It might be because you have certain types of evidence. Whatever it is, you do all the lists. And here, what are the reasons why you're not? And you do that pros and cons list. And after you've done that, you assign a probability to being successful. For example, you might say, if you're a defendant, I think I've got a 75% chance of success on summary judgment, looking at all those pros and cons. But you need to establish a probability statistic, not a range, but a statistic. You would do the same thing for the trial. If I don't win at summary judgment, what's the probability I'm going to win a trial? You might say I've got a 40% of trial versus my 75% chance, which I was referencing for summary judgment. You go through that, the same process. What are the pros and cons? And in a minute, I'll come to this decision tree and we'll talk about it in some specifics. Now, with respect to a lot of times, you're going to want to say, hey, I think it's going to be between 40% and 60%. That's not particularly helpful when you're dealing with the primary uncertainty. But sometimes you can do ranges. And if you want to do a range, you can do a range where it's high, medium, and low, and then you get a weighted average. And when we go through this example that's up there, I'll show you how the weighted average works. So all you're really doing here is multiplying the risk of liability, the various different risks of liabilities, and you're then multiplying them together, and you get a projected risk of liability, and then you turn around and use that risk of liability, and you multiply that times each of them. This example, I've got low, medium, and high, and you'll come out with a damages calculation. And as I say, I'll run through that more specifically in a second. This is probably one of the more critical things about this that I know I want to discuss here briefly. When I ask a plaintiff or defendant for that matter, I'll say to you, let's just assume it's a simple employment case, which I did a long time ago, but I still remember how those conversations went. I would say again, I say, what's the probability you're winning this case? And the plaintiff's lawyer would inevitably say to me, oh, I think it's 70% or 60%. And I'd say, well, how'd you get there? And they say, well, it's 50-50 and I've got the better side of it because of A, B, and C. And I'd go, uh-huh. And my reaction instantly is, frankly, you don't have the foggiest idea what you're talking about in terms of how to do a risk analysis. A risk analysis is done using not 50-50, but the base rate. What is the base rate for the particular uncertainty that you're analyzing? Let's take, for example, summary judgment in the example I've got up here. I happen to know what the probabilities are, at least in the Northern District of Georgia, where I practiced when I last practiced. The summary judgment rate for a defendant was up as high as 85%. And when that's the base rate for summary judgment in an employment case, the starting point is that base rate, 85%. That's what's known as the external base rate. And the starting point is there. And if you don't get anything else out of this other than the thought that you might start using decision trees, you must start with the external base rate. This fellow, Philip Tetlock, who's a professor, I think he's at Pennsylvania nowadays, University of Pennsylvania, he wrote a book called Super Forecasting. If you're really interested in how to do predictions, read the book Super Forecasting by Philip Tetlock. I got it as a paperback. I think it costs $20 or something, but it's a fascinating book. One of the things that he talks about, and I'll use an example, it's not exactly the same example, but let's say the issue is something as silly as this. You want to know what the probability of whether a public figure, and I'll pick one out of the hat, I picked Jay Leno, has a pet dog. What's the probability of Jay Leno having a pet dog? Well, I can assure you, you don't start with the underlying proposition of, let me see whether Jay Leno likes dogs or not. That's not the way to do it. You start with the external base rate of what is the probability of a person who lives in the United States or lives in whatever the most narrow one you can get, but let's call the person living in the United States, will have a dog. That's the external rate. And then you adjust up and down from there. For example, you might look at whether the person lives in an apartment or a home, how much do they travel, do they have children, and a variety of other factors that affect whether or not somebody's going to own a dog. But that's the internal adjustment. So when you're doing in litigation, you start with the external rate and you move to the internal rate. One of the next things that you must do, let's assume that you come up with a summary judgment percentage of your own and you think it's 85%. That's the one you got from doing your pros and cons list. The next thing you need to do is you need to look at the probability of bias. Bias affecting your judgment. We all are biased in everything we do, and it's not a question of like racial bias or anything like that. We're biased in our judgments. We're biased because we have instinctively biases such as, and I'll just list a few and I won't go through them, but framing, I got a list here, framing, anchoring, confirmation bias, self-serving bias. Self-serving bias drives very much so how you reach conclusions. I wrote an article a couple of years ago that appears in one of they wanted it from Harvard Law Review, but I turned them down. I decided I'd put it in the American Journal of Mediation, which is, everybody knows, that world famous journal. But the article, what its premise is two lawyers having essentially the same information, and they come to a different valuation. Why did they come to a different valuation? And the primary answer for that is the biases we have, and one of those, to say the primary one is self-serving bias. We have others like overconfidence bias, endowment bias, and so forth. But how do you debias, which is even more important question. And the primary way that I think you can debias is this: assuming you have a trial team, and it's even at the beginning of the case, you take your team and say, look, we think we can file for summary judgment. You tell me what happened here because we just lost summary judgment. I want you to list all of the reasons why we just lost summary judgment. And then you take that list from your trial team and you brainstorm over it and have that impact your percentage, whether it was 85, 75, 65. It might go up, it might go down. Likely both sides will adjust those in a negative way. In other words, the defendant will go down and the plaintiff will adjust theirs downward also. With respect to other things you might do that you may or may not have done, but these third-party focus groups are important. Mock trials can be helpful. And of course, then you sit down with people who have done these kinds of cases and say, this is the conclusion I've reached. What do you think? Do you think I'm too high, too low, and so forth? As for client costs, they're different for different clients. But of course, it's the obvious ones of disruption to the operations, reputational costs, costs for discovery, and so forth. They all can be very important, just for the example I gave you. With respect to client costs, you subtract that from whatever you thought your analysis came up with in terms of dollars. For the defendant, you add it to that, and of course, you do the same thing for the cost of defense for the defendant. If it's a fee shifting case, then of course the plaintiff doesn't have a quote cost for the plaintiff. That becomes another risk analysis. So let me run through this, and this will take 30 seconds. I'm looking at the decision tree over here, and let's assume no settlement. Let's assume you came up with a 75% probability of summary judgment being granted, and that's going to cost you $50,000 to get to summary judgment. You go down to the other branch and you see summary judgment denied. That's at 25%. So obviously, if summary judgment is granted, the case is over. Defendant had to pay $50,000 and we move on. But let's assume summary judgment is denied. And that's a 25% probability, and that's been assigned here. For the next assigned ones, the defendant's verdict, 40% success rate, plaintiff 60% success rate. And what we're saying here is that the plaintiff fees are $75,000. The defendant fees overall, and of course this is very hypothetical because it would be more than this, but it's $75,000. That's the total amount of defense fees to go through trial. Same thing for plaintiff's fees. So now we look at the low end of it here, and it's 25%. The middle, and that's $100,000. That $100,000 consists of plaintiff's fees plus the projected recovery. Here, the projected recovery is $25,000. Fees are $75,000. That gets to $100,000. The medium we place at 50% probability, and again, these are just numbers I've put in here. $100,000 for the recovery. $75,000 fees get you $175,000. On the high end, it comes to a total of $325,000. So let's look at the math down in the box. For the plaintiff side, it's going to be the defendant's side too, for that matter, is 0.25, that's your summary judgment number, times 0.60, that's going to be your probability with respect to getting to liability. And then you look over in the low end, it's 25%, so you say, okay, 15.15 times 0.25, and that's 0.0375, times the 100,000, and that's 3,750. So you go through that same analysis there, 13,000, 12,000, that adds up to a total of 29,062. On the defense side, you've got to add their number in, and that's going to be at a 75,000, so you're going to have a defense value of 104,000. Okay, so I ran through that pretty quickly, but that obviously that's going to be available to you. So with that, I mean, I ran through that relatively quickly, but we're limited in time. So I hope that gives you some decent idea of where things go. Eric, back to you.
Thank you. Yeah, thank you, Hunter. And before I forget, since we're basically 5 minutes from the end of the presentation, let me go ahead and read out the CLE code. It's SS, as in Seyfarth Shaw, the letter SS 2983. So SS 2983 is the CLE code. A couple quick questions for both of you in our remaining minutes. Hunter, I'll start with you. You talked about biases and personal biases, and I realize every case is different, every scenario is different, but any tips for checking or unearthing our own personal biases? Should we reach out to others, or, how do we find out if we actually have a bias that, maybe we're not aware of, we're not adequately accounting for?
Well, I can't tell you which bias, but this brainstorming process that I talked about, you take your trial team and you say to them, let's assume that you just lost at trial. Pick wherever you want to pick. I want to know what you think all the reasons are. And that forces you to start thinking about the other side's case rather than thinking just of your side case. And when you do that, there's actually some studies showing that that does militate against some of those biases. But there are literally scores of different kinds of biases that you can have. One of which is one of the most powerful one of all is anchoring. And the anchoring bias is something that you have to be very careful about. And I think when I think I've made some progress on it, is through from extensive reading about how people get anchored and what causes the anchoring, and understanding the process is one way to get around it.
And for you, Professor, my initial question I had for you during your presentation was, you had the chart up about the bargaining zone, and I realize this is a fairly broad question, but in a negotiation where so many times there's so much posturing going on about what someone's real bottom line is, or what someone's willing to pay. Any tips from your end in a sort of a business scenario about how to flush out the sort of true bargaining zone? I mean, because we don't live in a world where everybody just lays all their cards out on the table at the outset.
Yeah, Eric, I could not agree more strongly with your premise. If only it worked that way. And so to me, that's why it's so important. As Hunter said, preparation is the best predictor of success. So first of all, the more research you do ahead of time, the more you hopefully will know what is a reasonable deal in scenarios like this. Part two, look at your own interests for yourself or your client and what's okay and what's not okay. That will at least give you a range of what's acceptable or not, because it's the most important thing is you're responsible for your own and or your client's interests. From there, yeah, people play games. They'll say it's non-negotiable when it is, or this is my final offer when it's not. And then you'll have a sense, it won't matter as much because you'll have a sense as what is possible or not based on the research you've done ahead of time.
Yeah. I'll say too, the other, you highlighted the competitive versus collaborative negotiations, and I think that's just so critical, even if certainly in the litigation context where, when you enter that negotiation, you've got to identify whether or not you're dealing with a truly competitive situation or not. And if you try to extend olive branches and you try to play the collaborative role, that's when I see, and the other one's purely the competitive. I mean, isn't that when you just get sort of ripped through a buzzsaw?
Yep. I'm helping with a divorce mediation now. It's a great example of that because some are collaborative and they use the same lawyer and they want to be, but then they can shift to competitive, and some are just nasty and terrible. So any type of negotiation can go either way, and some can shift from one to the other and get really nasty and ugly big time.
Yeah. You got to be on your guard. In other words, I mean, it could start off collaborative, and in my experience, if you continue to be collaborative when someone clearly is giving you all the signs not to be, that they're competitive, they're just going to keep taking
Yep.
the whole.
Yep.
Yep.
You're absolutely right.
Yep. Well, the hour went by very quickly, and we want to be mindful of everyone's time. I will just echo at the end, first and foremost, thank you all for joining us. We could speak for obviously hours and hours and days on these topics. We're here to be, all of us, I'll speak for the panel, are here to be a resource for you. You'll have our emails, email us, email any questions, follow-up questions, happy to provide any materials y'all like. And again, we can't thank you all enough for joining us, and appreciate everyone's time.